So we'll begin with looking at the issue of identification of meaning in a social media context. We will look at the relevant case law that sort of sets out the general principles for that, and then we'll look to be more specific in terms of how that works in a social media context, to do particularly with Twitter and Facebook, as we will see. We'll then go on to look at serious harm. We won't spend a huge amount of time on that today. We'll look at a couple of cases, as we'll see in a moment. On another occasion, I've recorded a whole 1 hour session recently on this, so by all means do have a look at that if you wish to do so. But we'll just dip into that against the background of social media and online content. Third thing will then be the issue of defences. Now, you may well be aware there's a whole raft of defences out there. We're going to focus on two of those that have emerged in recent cases to do predominantly with Twitter, and they are the defences of truth and matter of public interest. And finally, we'll look at remedies. Of course, the reality is that people, when they bring these sorts of claims, want to often recover damages. They may also be after costs, possibly an injunction and various other things. And we'll look at two examples of that at the end of the session. So let's just take each of these in turn very briefly. First of all, we acknowledge that the governing principle when we're looking to identify meaning is reasonableness. So that will have an impact on some of these other things that we say in a moment. The next thing we note is that the intention of the publisher, so whoever published an online article or indeed made a Twitter post or a posting on Facebook, or as we'll see later on, some form of recording on YouTube as well, their particular intention is irrelevant. Now, what's interesting to note is that the court then goes on to say how the defendant could have avoided falling into the trap of effectively defaming the claimant. So have a look at a little bit of guidance here that's well worth bearing in mind if you're advising a client about something they're about to say, or perhaps thinking about whether a particular defense of truth might be of assistance to you or your client. So the judge goes on to say the defendant could have avoided effectively all of these problems if they had said the claimant had posted a tweet which was capable of suggesting that Jeremy Corbyn deserved to be violently attacked. Well, then she may well have had a viable defense of truth.